Hi everyone, this is Mallory Flowers on behalf of Jennifer Shelton and Associates, and we are coming to you live from Washington, D.C., and welcome to our Webinar Wednesday series. Our webinars are held every Wednesday in 2018 at 12 p.m. and 12:30 p.m. Eastern Time, and our speakers range from accountants to attorneys and other industry professionals. The full schedule for the rest of the year is on our website underneath the Webinar tab. In the interest of time, we do not take questions. Our speakers' contact info is posted on the last slide, so if you have any questions, please contact the speaker directly. The recordings are on our website underneath the Archived Webinar tab, as well as on our YouTube channel. All right, this just is a quick blurb about us. Jennifer Shelton Associates is based in downtown Washington, D.C., and we help both product and service companies with federal contracting. Our clients are domestic and foreign, defense contractors and civilian, and our services range from market analysis reports to contract vehicles, including the GSA schedule. We can also help you with proposal writing and post-award contract administration. More information about our services and upcoming events can be found on our website. And this is one of our upcoming events on October 22nd that you can find more information on our website or also on the link you see on the screen. And these will be sponsors and federal agencies that will be attending. All right, we're going to go ahead and dig into today's presentation, which is Managing and Mitigating Procurement Risk, and Margaret Cassidy is our speaker today. You can learn more about her background on this slide. Thank you, Margaret, for joining us, and I'm going to go ahead and hand it over to you.
Thank you, Mallory. We're going to discuss today managing procurement risk through the government contracting process. Mallory, you can go to the next slide. So the first question is, what is a procurement risk? And it flows from the Procurement Integrity Act. And why should you care if someone's seeking government contracts? Because the government makes it illegal to disclose what's called procurement information. It also makes it illegal to obtain procurement information. It also prohibits recruiting and hiring from the government if you are a government contractor and engage with activities in a particular agency or not. Government employees should know these rules and regulations. Sometimes they do, sometimes they don't, but you need to be alert to them as well, because doing it improperly exposes you and you personally, as well as your organization, to criminal liability. But that's for another day. We're going to talk more about the procurement process itself, what the risks are, what the government prohibits, and what you can do to manage it. Mallory, you could go to the next slide. So procurement information covers a lot of different types of data and materials. It covers bid prices in response to any sort of agency request for bids. It covers proposed costs or prices in response to an agency solicitation. But it also covers the cost and pricing of your competitors, which would include somebody that you maybe are having a teaming agreement with or that you're subcontract prime relationship with. It includes source selection plans. It includes technical evaluation plans that the government are putting together in the course of evaluating a proposal. And it includes competitive range determination, rankings of bids, or anything of that nature. It includes the reports, the evaluations from source selection panels, boards, advisory councils, or any other information that is marked source selection information, because its disclosure would jeopardize the competitive nature of the contracting process. But it also covers proprietary information that other government contractors have marked as contractor bid or proposal information, or have marked as contractor source selection information or contractor procurement information. So the important things to take away from this slide is, number one, you need to be alert and be able to identify and know what procurement information is. Very, very broad definition, both when it comes to information that the government considers procurement information and both what you should consider as procurement sensitive or proprietary information that you should mark, and what your competitors consider procurement sensitive or proprietary information. What this means is, first off, you should mark it so that it's clearly identified as something you consider to be protected information. You also should assure that you get your non-disclosure agreements when you start doing teaming or subcontracting with another business, so that it's clear to them that you expect your information to be protected. The overarching theme around procurement information is that you want to avoid improperly getting any information if it would give you an unfair competitive advantage in a procurement opportunity. And it doesn't matter whether it comes to you accidentally whether you get it as part of a contract you're currently performing, or whether you get it through a competitor or a teaming partner. You still have to treat it the same way. But this is the world of information that needs to be protected. Miller, we can go to the next slide. So the government has, as I've already indicated, some laws and regulations that make it illegal for you to either get procurement or source selection information when you're not entitled to have it, or use it in any way if you are entitled to have it. And the reason these laws exist, and mind you, they can be criminal or they could be civil, is because the government has the same concern that you do with your competitors. The government doesn't want you or any other federal government contractor to have an unfair competitive advantage in the procurement. And the source selection laws and procurement laws are designed to protect that. Part of that protection is what we just talked about, the procurement integrity information. Information that, if you have it, is going to give you inside information on how to be more competitive in pursuing a particular government contract. It could be information from the government that is inside government information and thus gives you a competitive advantage, or it could be the inside information of your competitors that gives you the inside information that gives you an unfair competitive advantage. So when trying to determine if you're in a situation where you've either been exposed to, or you have access to, or you've obtained or otherwise received procurement sensitive information that might be subject to these laws, you should ask yourself if having the information that you have is going to give you an unfair competitive advantage in the course of that procurement. If it is, then there are certain steps that you need to take, and we'll talk about that in a moment. But what can happen, and what your competitors can do, is they could protest the award if you get it. If the government finds out about it, they could pull the opportunity and so do a do-over or something of that nature. It could also result in investigations. It can result in investigation by the Inspector General of your agency. It could result in an investigation by the procurement shop of your agency, by the Department of Justice, or other organizations. The investigation could be either of your company or either of the individuals involved in accessing, obtaining the procurement sensitive information. It can also result in suspension or debarment, or criminal or civil penalty. So it's important that you stay alert to how you get competitive information, whether it be government information that has not been publicly available or competitor information. Mallory, we can go to the next slide. Mallory, we can, okay, thank you. So not only is just possessing the procurement sensitive information when you're not entitled to have it, or using it to an unfair competitive advantage, a problem or a procurement risk that you face as you're going through the procurement process, but because it's a conflict of interest. Ultimately, it is a conflict that gives you an unfair competitive advantage over competitors who did not have the ability to access, obtain, or use that competitive information that was obtained from the government or your competitors. But there's other types of conflicts of interest that you need to be aware of as well. If you as an organization provide supplies or services to the government in a way that assists the government with drafting the RFP, generally you're prohibited from turning around and bidding on that RFP. It presents a conflict of interest for your company as an organization because you're writing the rules of the game. If you write the rules of the game, the government's theory is, that is, help draft the RFP, then turn around and bid on the RFP, you have theoretically drafted that RFP in a way that puts you in the best position to win. The government considers that a conflict of interest that should not occur. It can happen in other ways, though, too. Again, referring to another procurement risk, is that if you write detailed white papers, or if you give detailed ideas to the government about something that in the future they could turn into an RFP or an RFI, and you have drafted that white paper or that guidance for the government in such a way that it appears that you've written the RFP or the RFI, then the government's going to take the position, and probably even more so your competitors, that you have written the rules for that competition and that you should be excluded from that competition. Even if you have no intention of doing that, if you write a detailed white paper that the government ends up turning around and using as an RFP, and your competitors look at the metadata or other information and they realize that it's a document that your company wrote, they're going to challenge that. They're going to challenge that procurement. They're likely going to win that challenge, and the government will have a do-over. So you need to be alert of the fact that when you write white papers, give them over to the government, that at times some of those government persons just may take that and dump it, your white paper, as a statement of work into an RFP. That you should try to avoid. Another way that you can end up in a conflict of interest that is prohibited by the government is that you end up reviewing your own work that you performed on a previous contract. So there's a famous case out there where two companies were competing to evaluate underwater weapon systems. One of the underwater weapon systems in use had designed about 20 of those underwater weapon systems. That company was awarded the contract. The other competitors in the procurement process challenged that award, saying that the company who designed the weapon systems, the underwater weapon systems, cannot then, in a later contract opportunity, turn around and evaluate the effectiveness of those weapon systems. The court agreed, and the court ordered the Department of Defense to redo that acquisition because the company that designed the weapon system could not be the one that evaluated the performance of the weapon system. But it just doesn't happen in that situation as well. If you help the government develop an IT system, if you help them do any sort of business process improvement or business flow improvement, and later an RFP comes out that asks for somebody to evaluate the effectiveness of those improvements, bidding on that and getting awarded that contract would put your company in a conflict of interest if you were the one that designed that work. Then the last one that we've already discussed is accessing government information that other contractors do not have, which is the unfair competitive advantage that you get through accessing or obtaining government information that's sensitive and not public, your competitors' information that's sensitive and not public. So how does the government manage this procurement risk? One of the things that the government does is when you are given an RFP and you're responding, many times it asks you to affirmatively certify that you have no conflicts of interest. You can't make that certification without doing adequate due diligence to assure that you do not have a conflict of interest. However, even if you have a conflict, it doesn't mean that in no instance may you get awarded that contract. Instead, if you can come up with a plan to explain how you can mitigate that conflict of interest, and you disclose that conflict of interest to the government, give them your plan on how you're going to mitigate that conflict of interest, or which means essentially neutralize the conflict of interest, then the government will often still, if they're comfortable with your conflict of interest mitigation plan, still award you the contract to perform if in fact you can mitigate that conflict. Sometimes that is merely segmenting your workforce so that the persons who help draft the RFP are in fact not going to be the ones on the team that is going to bid on the work related to the RFP. If you do have access to non-public government procurement information, again, building an ethical wall between your people that had the access and those that didn't, and being able to demonstrate to the government that you not only put that wall in place, that everyone who needed to know about that wall knew about the wall, that they were trained on that wall, and that wall stayed in place throughout the execution of those contracts, will give the government assurance that you're trying to mitigate your conflict of interest. We're going to talk a little bit more about that on the next slide. And remember, if you're a prime contractor, it's your responsibility to make sure that your subs don't have conflicts, and that if they do have conflicts, that they disclose those conflicts in a timely fashion, not only at the beginning of the contract, but over the life of the contract, and then that those conflicts are mitigated if need be, or if they can be. Even though you can develop a plan to mitigate a conflict, remember there's many occasions when the government says that the conflict is it's too serious, it's too complex, and there's no way to mitigate that conflict of interest. If we can move to the next slide. So what are some of the things you can do at a very basic level to manage your procurement risks around, first off, getting procurement sensitive information either from the federal government or from your competitors? And remember, there's a couple ways. I've been referring to getting non-public information from the government or procurement sensitive information or proprietary sensitive information from your competitors. It generally can happen in two ways. It can happen accidentally. So the government sometimes will inadvertently mail procurement sensitive information to contractors that it's actively working with. Your name or those in your company's names may appear or pop up as the government starts to put an email together. They don't notice that they're sending something to a contractor. Your name ends up on the email. It is the list of bidders and the bid ranking for a competition that you are involved in. It happens. It happens all the time. What you need to do is make sure that you have a way to deal with it, which we're going to talk about right now. It can happen if you work on site in the government agency and you walk into the conference room that the government has promised you up and down is your conference room to work out of, and they'll make sure that there's no government sensitive information in there. You walk in there early in the morning, and what do you see? You see the list of bidders and the bid ranking on the whiteboard in the room, and you see the proposals all over the desk. Even if you don't look at that material, you have a problem that you're going to have to address. And we're going to go over a list of some of the things you can do. The other way you can get procurement sensitive information or proprietary information is through your current government work. Perhaps you're working in a program management capacity and you're helping the government manage a acquisition or manage a procurement. Or perhaps you're working with other contractors where they're going to be your subcontractors, your teaming partners through the course of a competition. You need to make sure that in the instance that you're working with teaming partners or other subcontractors, that you do get your non-disclosures in place, that you honor those non-disclosures, and that you do, in fact, undertake what is required of those non-disclosures to make sure that you're not getting one another's sensitive information through the course of that opportunity or through the course of others. And if you do get it, if you do just agree to share procurement sensitive information, you can't then go off and use that for other opportunities or other competitions that are not the ones specified in your NDA. From the government side, like I said, you could get it if you're the program management team for an acquisition. You can get it if you are involved in auditing or investigations that you are given, the government gives you a contract to look at different procurement, the finances, the invoices that are coming in for different procurements. If you're looking at all that information, that is the access to non-public information that is prohibited for a contractor to use for something else other than what you get access to it for. So what should you do? So from the very get-go, you need to actually know your company's contracts and know your company's subcontracts. But you need to know what agency you're doing the work for, and you need to know generally the nature and scope of your work. And when I say your company needs to know this, somebody significantly high-ranking enough in the company needs to appreciate this so that they're going to be able to look out and understand what opportunities are getting pursued and what work you're currently performing. So that's the next thing you should know. What are you reviewing your opportunities for your opportunities to determine if there is a conflict of interest? That's why you need to know the nature of the work that you're already performing, under what contract, under what agency. Once you know that, then the next step is as other opportunities come in out of those agencies where you're working, you have to ask yourself, is the new work, if I bid on it or if I pursue this new work, is it going to conflict with the work that I'm currently doing? And by conflict, I mean it's going to give you an unfair competitive advantage, or it's going to allow you to help set the rules and then you're going to win the game. Those types of conflicts that we just talked about. Next, you should have policies and procedures to make sure that you're identifying procurement sensitive information, that you're identifying when you get your competitor sensitive information, because remember, sometimes your competitors are your teaming partners, your subcontract partners. Also, you need to have policies and procedures that explain how you're going to identify conflicts of interest, who's responsible for that, who's going to own the identification process. Once you identify and do in fact have an actual, apparent, potential, or perceived conflict of interest, through the procurement process, you need to disclose that to the government. You need to have policies and procedures around how to make those disclosures to the government, and policies and procedures on what you're going to do to mitigate conflicts. Conflicts can be mitigated in a number of ways. Once you have the policies and procedures around these procurement-sensitive areas, then you need to make sure that everybody in your organization is trained on them, or at least everybody who's going to be involved in the procurement process or who may have the opportunity to get procurement-sensitive information. Have somebody who's an objective, knowledgeable person identify and manage conflicts of interest. It could be any number of folks in your organization, somebody that would have the insight into the contracts that you're currently performing, insight into the opportunities that you're going to pursue. Because sometimes you may want to pass on an opportunity because you'll know in the future there's going to be follow-on work. Maybe you don't want the design work for the IT system. Maybe you prefer to have the evaluation work. So you need to have somebody who is strategic enough and knowledgeable enough about your work and about conflicts to decide whether your organization is A, going to have a conflict, and B, what should it do about it, up to and including potentially passing on earlier work in order for the strategic benefit of getting later, which may be more lucrative work. In the event you are engaged in a contract with the government where you are in fact getting access to procurement-sensitive information, or in the event someone in your organization inadvertently gets procurement-sensitive information, you need a plan to be able to wall those people off. Not only the people off, but you need to be able to have a plan to wall off the IT systems so that people cannot access that procurement-sensitive information. Part of that plan should be that if the person gets procurement-sensitive information, they go to somebody in your organization. If you have a lawyer, it should be the lawyer. If not, it should be your external counsel. When your company, an individual in your company, gets procurement-sensitive information inadvertently, or if somebody in your company gets the information but thinks it's a good idea to use it, you need to train consistently to let your people know, either go to your lawyer, go to your external counsel, or go to somebody before that information is shared across the organization. If you get non-public procurement information, either from the government or your competitors, accidentally or on purpose, and you start sharing that across the organization, and that information could give you an unfair competitive advantage, whether or not you use the information, the government finds out about it, finds out about the fact you got the information, you're going to likely be excluded from that procurement. So if somebody gets procurement-sensitive information, you walk into that conference room and you see the bidders ranked on the whiteboard. You get the email with the source selection plans. You need to have a method to wall that person off, wall their email off, establish that you did it, and keep that person out of the procurement. Sending that information around and discussing it is like passing a virus through your organization. That virus is going to infect you to the degree that if the government finds out about it, and you probably have the obligation to disclose you got it, then you're going to be kicked out of that acquisition process. Which brings me to my next point. Have a plan and methods to disclose to the government as needed. When you get the information accidentally, if you have the information because you're performing a contract, or if you have other conflicts of interest that need to be disclosed, make sure that you have a plan and you know how to disclose it to the government as needed, and it's not some sort of fire drill at the last moment. Last, a very effective thing to do is to develop a conflict of interest mitigation plan template so that you can use it and adapt it to the different situations. It should include how you're going to wall people off, how you're going to wall off your IT systems. It should include the nature of the training that you're going to do. It should discuss who in the organization is going to have oversight of the mitigation plan. It should include how you're going to audit that mitigation plan to make sure that over the life of that plan, it's going to continue to operate and work as you told the government would. So those are some of the things you can do to identify conflicts of interest, identify the procurement risks as you're starting to go through an acquisition process. And that wraps up what I had to say today.
Awesome. Thank you so much, Margaret. And thank you for everybody who joined us. And again, like I said, if you have any questions, you can reach out to her here with the information you see on your screen. 12:30, we are covering basics of opportunity capture. So join us then. Thank you, everybody.
Thanks.